لا إله إلا الله محمد رسول الله.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين والصلاة والسلام على أشرف المرسلين نبينا محمد وعلى آله وصحبه أجمعين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Ahlan wa sahlan wa marhaban bikum. I welcome you back to our course on understanding Shafi'i Usul, Imam al-Saqqaf's Mukhtasar Al-Fawa'id Al-Makkiyya, essential principles for Shafi'i students, insha'Allah ta'ala. In this lesson, bi'idhnillahi ta'ala, we focus our attention on conditions for invalidating a judge's ruling. In other words, under which circumstances can we override rules that already exist or that have already been established, right? So covering the rules in sacred law, governing, overriding rules. Our course outcomes remain the same. We wish to have a comprehensive understanding of Islamic law. We wish to master scholarly etiquette and ethics and familiarize ourselves with key Shafi'i texts and terminology, as well as to enhance our spiritual and intellectual growth bi'idhnillahi ta'ala. This lesson focuses specifically on pages 58 to 60, identifying conditions of invalidating judicial rulings, recognizing the role of Quran and Sunnah and consensus in judgments, and understanding examples of rulings subject to invalidation. And then some key concepts in this lesson: naqd, which is invalidation; hukm, which is a ruling or judgment; ijma', which refers to scholarly consensus; and ikhtiyar, which is a personal view of a scholar different to that of his madhab. Now, naturally, there are specific definitions here for each of these terms, but that's not the point of key concepts. It's to point out certain concepts that are key to this lesson and that it is sort of important and critical for a student to have an understanding of ahead of time, bi'idhnillahi ta'ala. So from that point, we then proceed to speak about a question: can a ruling be nullified and how? So we are, of course, aware that we have differences of opinion. So we could have several scholars, all of them having differing views on one particular point. How then can we speak about a ruling being nullified? We're not speaking about differing views, that there's one view and then somebody else brings a differing view. We are speaking about there's a view, but it needs to be nullified, or it is by rights nullified. How does that come about? So this is the third point in the Fawaid that we said our author is bringing after the previous major section. الثالثة شروط نقض حكم القاضي, and it speaks about breaking or the conditions of breaking the ruling that has already been decreed by a judge, by a mujtahid. قال في التذكرة, excuse me. So this book, تذكرة النبي من تصحيح التنبيه. There's several titles here that we need to be familiar with. This is a book in Shafi'i Fiqh. It was written by Abdul Rahim ibn al-Hasan al-Isnawi, who passed away in 772, and it is a sharh, it is a exegetical work on the Tasheeh al-Tanbih. The Tasheeh al-Tanbih is essentially the refinement of the Tanbih, which was written by Imam Alawiy rahimahullah ta'ala, who died 676, and it was a work that he wrote on the work of Imam Abu Ishaq Al-Shirazi. Not the Muhadhab. Imam Nawawi wrote the Al-Majmu' Sharh Al-Muhadhab, but Abu Ishaq Al-Shirazi also wrote another book, At-Tanbih, which Imam Nawawi also wrote on, right? So this is the Tadhkiratun Nabi, right? That is written from the Tasheeh Al-Tanbih. And he says in that book, وَشُرُوطُ نَقْضِ حُكْمِ الْقَاضِ, the conditions of breaking the ruling of a qadi. Then he quotes Imam Alawiy rahimahullah ta'ala. Minha, among the conditions, is كَوْنُهُ مُخَالِفًا لِنَصِّ الْكِتَابِ, is that the ruling in question differs with the textual evidence of the Quran أو السنة or of hadith سواء كانت متواترة أو آحادا. This is whether it is canonically transmitted or massively transmitted, or whether it is from an ahad transmission. أو مخالفا للإجماع, or the ruling in question differs, breaks a scholarly consensus. أو للقياس, or it breaks an analogy. What type of qiyas? Either al-awla or al-musawi. Remember, we get different types of qiyas or analogy. And this is, of course, only going to be applicable, or rather, this is only going to make sense to you if you've studied usul al-fiqh, which is necessary for this course. So, when we speak about qiyas, there are four major components of qiyas. We have the far', we have the asl, we have the illah, and we have the hukam. And with these four components in the discussion of qiyas, the major component where most of our study goes into is the illah, or the ratio legis, right? The legal reasoning for the existence of the hukam. Now, when we have a situation of qiyas where the illah is more prevalent in the new case than it is in the old case, classical example is abusing your parents physically, wal-'iyadhu billah. The original case speaks about وَلَا تَكُلْ لَهُمَا uff. Don't even say uff to them. The new case is physically abusing them. So this is a qiyas al-Alawiy, where the ratio legis is more prevalent in the new case than in the old case. This is equivalent to, in terms of strength, an ayah or a hadith, textually speaking. It is equal to that in evidentiary strength. A qiyas al-musawi is where the illah exists to an equal degree in both the original case as well as the new case. So if the case in question, the hukam in question, contradicts either type of qiyas, then it is a valid reason to nullify that particular opinion. And that's what the author is stating here. هذا بالنسبة للمجتهد المطلق. And the one who can actually do this and carry out this nullification of that particular opinion is the mujtahidul mutlaq, the unrestricted, independent jurist. Now remember, we spoke about the categories of scholars, right? And this was from the previous lesson. The mujtahidul mutlaq in this particular description would fall into the first two categories, the mujtahid mustaqil and the mutlaq muntasib. They would technically both be a mujtahid mutlaq of sorts. We continue from there and we look at the opinion of Shaykh Ibn Hajar rahimahullahu ta'ala, and he says here, now this is Ibn Hajar al-Haytami, and he passed away in 974, also a key figure of the Shafi'i school of thought, the author of the Tuhfatul Muhtaj, probably the most relied upon exegetical work of the Minhaj al-Talibin of Imam Alawiy, rahimahullahu ta'ala, because fatwa is passed according to Ibn Hajar and Ramli's commentaries on the Minhaj. So what does he say? He says, كون حكم المتبحر, right? There's a mistake here in the text on the slide, but the كون حكم المتبحر, the hukm, the ruling of a scholar, أي المجتهد المذهبي, a mujtahid within the madhab, مخالفا لنص إمامه, that goes contrary to the nas, the textual evidence of his imam, أو لقواعده الكلية, or to the general principles of the imam. فإن نص الإمام, because the evidence of the imam بالنسبة إلى المتبحر, in relation to the scholar who is a scholar within the madhab, كالنص الشارع بالنسبة للمجتهد المطلق. It is equivalent in terms of authority to the textual evidence of Allah, the Shari', the lawmaker, in relation to the Mujtahid al-Mutlaq, because that's the domain within which the Mujtahid Muntasib works, right? if you are a jurist within the framework of the madhab, then the framework of the madhab becomes the domain within which you work. Al-mujtahidu asiru dalil. Excuse me. The mujtahid is the prisoner of the evidence. Yasiru haythu sara dalil. He goes where the evidence goes. So who or what is the evidence for the mujtahid that's working within the framework of the madhab? The answer is the framework of the madhab, right? The evidence of his imam. ومنها كون حكم المتبحر أي مجتهد الفتيا مخالفا لما رجحه إمامه. Another example of this, he says, is where you have the ruling of a scholar in the madhab, a mujtahid that is a mujtahid al-fatwa, like Imam Rafi'i and Imam Nawawi, according to the previous categories, مخالفا لما رجحه إمامه, when their opinions go contrary to what the Imam had given preference to and made tarjih to. Now again, we're not speaking about ikhtiyarat, right, where the scholar has his own private view, his own personal view. We spoke about that. There's more to come about that as well. Here we are speaking the nullification of a view when principles are contradicted. Then continuing from there, he also says وَمِنْهَا كَوْنُ حُكْمِ غَيْرِ الْمُتَبَحِّرِ مُخَالِفًا لِمُعْتَمَدِ مَذْهَبِ إِمَامِهِ. If you have a scholar who's technically not a significant scholar in the madhab, and then he has an opinion, but his opinion is contrary to the relied upon opinion of the madhab that he follows, then this too can be nullified. لأنه لم, because he did not, let me just see, I think there's a mistake there. لأنه لم يرقى عن رتبة المقلد العام. No, it's correct. Because he did not yet traverse the station of being a general muqallid, a general follower. ومتى نقض حكم غيره, whenever a particular ruling is nullified, سئل عن مستنده, then the one nullifying it will be asked what the evidence is, what the argument is. وقولهم لا يسأل القاضي عن مستنده, and the saying that speaks about a qadi is not asked about his evidence or his argument, محله, the reference of where that is applicable, is إذا لم يكن حكمه نقضا أو لم يكن فاسقا أو جاهلا. That is when there's no breaking of his ruling, or he's not a sinner or an ignorant individual, right? That's the context of that particular statement. Then Ibn Hajar says in Tanweer al-Basair, it's Tanweer al-Basair, not Tanweeh al-Basair, ذكر الأئمة لبعض ما ينقض فيه قضاء القاضي أمثلة. The scholars had mentioned some examples of rulings that were sort of nullified or broken. And what are they? They are نفي خيار المجلس, the negation of the option to cancel within the sitting of the deal. ونفي إثبات القرابات, the negation of the establishment of close relations. ونفي القود في المماثل أو في المثقل, that's a mistake there, the negation of retribution with مثقلات, this is in justice, these are masails in justice. وإثبات قتل مسلم بذمي, again a mas'ala in justice. These are all examples that is basically stating. We're not going to mention the details of each mas'ala, that will take long. The point is these are examples of opinions that are considered null and void because they break the principles that we have been discussing. Again, like if you look at this, these are technical examples, so it's going to take a long time to sort of take them apart, and they are sensitive ones also. So for example, وإثبات قتل مسلم بذمي, right? وصحة بيع أم الولد, that's a matter pertaining to slavery. وصحة نكاح الشغار, ونكاح زوجة المفقود بعد 4 سنين مع عدة, وصحة تحريم الرضاع بعد الحولين. These are all controversial views that are considered invalid, right? This last one, for example, the complexity here is quite tremendous. the validity of still allowing family relations like milk nursing relations by milk nursing even after 2 years of age. So you can milk nurse an adult according to this view, but that view is considered to be null and void. So these are all sort of out of mainstream opinions that are not considered valid by mainstream. Then there are more as well. وَمِمَّا يُنْقَضُ مَا جَاءَ عَنْ عَطَاءِ بْنِ أَبِي رَبَّاحٍ min, and then there's opinions attributed to specific scholars like Ata ibn Abi Rabbah min ibahati i'arati al-jawari lil-wat'. I'm not going to even explain this. وَمَا جَاءَ عن ابن المسيب min تحليل البائنة بالعقد. Ibn al-Musayyab, a view attributed to him that you can still get married even after having a finalized divorce. وَمَا جَاءَ عن الأعمش, Sulaiman ibn Mihran al-A'mash, the great rawi of hadith, min jawaz al-akl fi Ramadan ba'd al-fajr. Subhanallah. وَقَبْلَ طُلُوعِ الشَّمْسِ, and before the sun rises. So again, I'm not going to explain these views. These views are not meant to be, they shouldn't even really exist in the English language because they are considered null and void. So we will leave it at third level Arabic students, inshallah. وغير ذلك من مذاهب المجتهدين, and other views of the madhahib الشاذة, which are considered anomalous, التي كاد الإجماع أن ينعقد على خلافها. Those views where there's almost ijma' against these views, right? فهذه كلها لا يجوز تقليد أربابها. So in these examples and others, it is not permissible to make taqleed of the ones to whom these opinions have been attributed. Tamam. So again, we looked at the maratib al-ulama, right, the ranks of the scholars from Hawashi al-Qulyubi, and we spoke about who you may make taqleed of and who you may not make taqleed of, and the abilities. So this is just a reminder of that particular lesson there. And then finally, we conduct the lesson summary. This is a shorter dars because the section ends and then there's another section, and we couldn't bring the two sections together. If we brought the two sections together, it's completely irrelevant. So we keep the segments separate, inshallah. We dealt with the conditions for the invalidation of rulings. We dealt with adherence to text. We dealt with the role of consensus and how consensus protects certain understandings of traditional Islam. And then we gave some examples of rulings that are not considered valid and in fact nullified. And Allah knows best. Tamam, that concludes lesson number 13, alhamdulillah. We continue in the next lesson with the final section of these fawaid, and that section deals with اختيارات للأئمة مخالفة للمذهب. As we said, it came before, we're mentioning it again. What happens when you have a scholar in the madhab who differs with the madhab? He's not nullifying or refuting the madhab, he just holds a view that's his private view contrary to the madhab. We see Imam Nawawi has many ikhtiyarat in this regard, and other scholars have this as well. Just some private views are more well known than others. So we'll deal with that section as well, bi'idhnillahi ta'ala, and that will then lead us to the end of this segment on fawaid, and then we move on to the next major section of the book, insha'Allah. Until then, jazakumullahu khairan for joining me. Wa sallallahu ala Sayyidina Muhammad, subhanallahi wa bihamdi, subhanaka Allahumma wa bihamdik, nashadu an la ilaha illa anta, nastaghfiruka wa natubu ilayk. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
La ilaha illallah Muhammad